SJC-11687, Commonwealth versus Chappell.
Good morning, Mr. Naaman. If you just wait one moment. Please proceed.
Good morning. May it please the court. My name is Steve Nyman. I represent Deshaun Chappell. There's a few issues in the brief right now. Given the time limitations, I'm hoping we can just focus on two issues. The first issue beginning on page 31, and that being the limitations of the expert testimony on direct examination that was contested by Mr. Solomon, the attorney for Mr. Chappell, at trial. It's our position that the expert who testifies as to the ultimate issue of criminal responsibility, or for that matter, any issues in which they're relying on prior records, evaluations, should be allowed to use the information upon which they base their ultimate conclusion.
You mean, when you say use it, you mean recite it in open court?
Recite that it was something that they reviewed, recite that there was that the substance, in essence, if in fact they relied on it, or even if they didn't rely on it, to be able to comment on it. There's
Get there, Mr. Naaman, if the judge gave the defense counsel an opportunity to put in whatever he wanted, and he declined to do it.
Well, I mean, so the defense attorney made a pretty good point. He said, I don't want those records to come in. I only want aspects of those records to come in. Allowing those records to come in would open the door to too many collateral things that he didn't want brought to a jury's attention. I think they were talking about the Mass General Hospital records, which were extensive. What he wanted to have his expert testify to was that there had been mental health commitments, there had been auditory command hallucinations from which the defendant had suffered, that this was not a recently contrived defense, but that there certainly was a firm medical basis for this, and that in order for him to arrive at his ultimate conclusion or opinion, he relied on these prior records. The defense attorney made some really
But the
good
defense
points.
attorney didn't want the records in?
He didn't want the records in. He only wanted portions of the records in, aspects of the records in, and he wanted to keep it limited. I think his concern, at least from what I could glean from the record, was they were too voluminous and too much collateral information about criminal history, violence, things.
Well, but they could have been redacted for that.
The assumption I'm making from these records is it was too much to redact, and basically you're redacting a whole cluster of records and just having sporadic sentences or paragraphs through a big stack of records that's obviously would present a red flag to a jury. So what are you trying to keep from me here? There's an awful lot of material that I'm not seeing. I'm only seeing bits and pieces that you want me to see. His approach was, let my expert testify that that's what he based his conclusion on. To challenge that, obviously the prosecutor would have the right to go forward and with whatever limitations the judge put on it, cross-examine it. Well, didn't you also see in that Mass General record from 2006 X or Y or Z? And then you can go forward with that.
But wasn't there considerable testimony from witnesses as to how the defendant appeared on any number of days? He had bizarre behavior.
Yes, there was. And
in his status at the house, I forgot the name of the house, Seagull House?
His status everywhere, and his mother and his grandmother's perceptions of how he had changed mentally since 2004 and how he had deteriorated mentally over the course of time until this happened in 2011. Yes, so that did come in. I think what Mr. Solomon was more concerned about, though, is you have an expert who is getting up and giving an opinion that's really going to be controlling as far as the outcome of the case. Is a jury going to believe that this person lacked criminal responsibility or not? That's coming from your expert. And the expert has to be able, from our perspective, to say, this is the basis of my opinion. There are tangible records out there that I relied on, and here is what they said. Not just, I reviewed records, and I interviewed the defendant.
it's
Here's
hearsay.
my conclusion.
Unless the records are in, which they could have been.
Well, I think one of the determinations that the judge could make, well, first of all, I'm not sure that it wouldn't actually fall within the state of mind exception to the hearsay rule. And the judge can,
How is the psychiatrist's or psychologist's state of mind relevant?
that he based his opinion on,
No, that's not
Things
really
that
the
were-
state of mind exception, is it?
well, I mean, I think you could make that argument that it certainly is. The other thing is the judge had to make the initial determination that these records were not made in preparation of litigation, but that they were in fact made for the purpose of treatment and diagnosis. So there's that
put the
veracity
records in.
component. But again, he didn't want to put the records in. And the other problem, and something that
I'm sorry,
even Justice,
so what's the theory here? I mean,
that's a depre-
there was cross-examination, I gather, of this expert,
right.
and on redirect, doesn't he have leeway to do what you say he was not allowed to do?
Absolutely. But you know what? And in,
What
in this
happened on redirect? Did he seek to put in that which he had been denied the opportunity to put in during his direct?
I think he got in what he wanted to get in. I think the point is, though,
So what's the harm?
because you don't want to make it look like your expert was hiding something, making a general callous conclusion that this person lacked criminal responsibility, and then you patch it up on redirect after the government has cross-examined and thrown some things in there that open the door. And Justice Locke had recognized that, yeah, perhaps this is somewhat of a problem, perhaps this, and for years that, and he had noticed the practice in the courts was not to use this standard, but rather that experts were in fact commenting on it. I think he used it in a civil context, but nevertheless, he had said that's the experience, but nevertheless, that's not the law, and he wasn't going to let it come in this way. But more of a...
But he was able to identify by name the records, wasn't he, that he relied upon? The commitment records at a certain hospital, the records at another hospital, statements of witnesses that may have been appropriate. He was able to identify them,
I
wasn't
don't
he?
know if you were... I don't know if he actually was able to refer to them as commitment records, but that he reviewed records. He reviewed records of Dr. So-and-so. And based on my review, I formed this opinion. But juries are smart. Well, what was in there that led you to that conclusion, other than your 2 hours or 4 hours or 6 hours?
If he could, I guess what I'm lost about is if he was entitled to put that in because it wasn't done in preparation, for the trial. These are prior commitments. If he was entitled to put that in, why should we say, well, because he didn't want to put them in? I mean, I don't see why that...
Well, I think what he was concerned about was two things. Number one, opening the door for things he didn't want in because of what was in those records and the collateral material. And number two, the redactions presenting this red flag to a jury about what are you trying to hide from me here? And that was pretty clearly what his concerns were. He's been doing this a long time. He's an experienced lawyer, and he knew that he had the option of bringing those in. I think perhaps more importantly is what was argued below, and what I see as a problem here too, is that the courts are relying on Grenadier, but Grenadier was a challenge in the reverse. It was the government trying to get these records in, the defendant saying, but I can't cross-examine. But the government doesn't have a confrontational right.
Yeah, but it seems to me, and I'm just sort of thinking of this off the top of my head, but let's assume it was it's the defense expert who wanted to talk about the direct records that had been done by somebody else, DNA, and they'd been done precisely for trial, but they weren't his or her test records themselves. So on direct, the defense attorney couldn't get them in. That's different than this case, isn't it?
Right.
Because in this case, the defense attorney could have gotten them in. In other words, because these are...
Under 79G.
Right.
Right. He could have, he could have gotten them in, but
No, I
you're
understand what
talking
you're
about
saying
those-
about redaction and all the stuff, but it does seem to me it's different than a situation where the attorney on direct, which could be a defense attorney, has an expert, isn't able, because the records themselves aren't admissible, isn't able to get before the jury the bases of his opinion. All he can say is, I relied on whatever, but without getting into the substance. That's a different case than this one, it seems to me.
well, in some regards, it's a different case, yes.
Now, in this case, if you had been able to, or if trial counsel had been able to do what he was trying to do, and limit the portions of the records, on cross-examination, couldn't the prosecutor have used the balance of the records that he wanted to, that the psychiatrist did not want to rely on?
I would think, well, obviously it would be in the judge's discretion, and I would think yes, but there would certainly be some litigation surrounding what would and what wouldn't be admissible in cross-examination. So in a case like this,
You mean
anything...
the psychiatrist's selective use of certain information in the records is
I don't think there's necessarily selective...
determines what goes on, the scope of cross-examination?
No, I agreed with you that I think in cross-examination, some of it would, but some things are not, that are in medical records aren't really relevant to what the opinion of the doctor
Well, that
is
could have
gonna
been
be.
redacted. Or the judge could have said,
Right.
you know, you can't get into
Absolutely.
that.
No, so I'm agreeing with your point. I'm agreeing that, yes, on cross-examination, the prosecutor would have been able to likely elicit material that the defense attorney did not want to get in. Not all of it, and that would be the subject of further motions, I would assume, and the judge would limit and say something, yes, this is certainly relevant to his credibility and his ultimate opinion, and no, this is completely collateral and prejudicial and has nothing to do with it. So but
Was such a motion filed in this case prior to trial? A motion in limine to prevent the prosecutor from cross-examining the psychiatrist on particular areas of the records?
No, but, you know, and maybe they're both really experienced lawyers, Mr. Solomon and Mr. Zabin. Maybe there was some understanding ahead of time of what is and isn't going to be used, as is often the case in the murder cases. You sort of try to streamline some of the things that would make the case unnecessarily long, and this isn't. These are two people that are getting right to the point and doing things the right way. So, and I really do make that assumption all the time that you're sort of parsing out what you know you can and can't use, and particularly in the homicide unit with the prosecutors, is they understand you don't want to make a mistake by bringing in something that's just terribly prejudicial. You do have an obligation to be fair, and I think for the most part, they are. So my assumption is here, a lot of that material was discussed, and they didn't have to bring it in terms of motion and limine. And what was contested was brought through motions and limine. What's interesting, though, is what Judge Locke did note, and it's been the practice, is that for years, you present your expert testifies to these things. There's only certain judges, you know, that say that's not the law, or certain prosecutors that say, well, wait a minute. For the most part, this stuff is streamlined. You know what's going to come in, and it's made a little bit smoother. And again, the focus should really be on, when you talk about Grenadier, that protection was for the defendant on constitutional grounds. The door should be open a little bit here, with the understanding that this...
But that was a purely common law case. It was decided on the grounds of DYS versus a juvenile, and it said that our common law provides greater protection than the Sixth Amendment.
Right. But again, we've always done these things with challenging what the government's trying to bring in without proper authentication versus the defense presenting a case. And the protection's always been that Sixth Amendment. And now it seems like the tables have been turned against the defense in these cases.
But hasn't DYS versus a juvenile said for, I don't know how many years it's been,
86?
30, 35 years? Yeah. It says that expert witnesses cannot rely upon, or they can rely upon independently admissible hearsay, but if it's not admissible at the trial.
Well, ultimately, it is admissible in some way because it typically comes in. I think the danger is if the prosecutor just says, I'm not going to cross-examine at all on this, for instance, in this case, I'm going to let your opinion come in without that basis. I'm not going to cross-examine, but I'm just going to put Dr. Kelly on in rebuttal. I think that's where you're going to have a problem someday. As a practical matter, in most cases, once the prosecutor starts to cross-examine the expert, the door is open because they start getting into all these things that works.
Did any of the prior records go before the jury at some point? The prior medical records?
I actually don't, I don't recall. That's a very good question. I don't recall. I know that the information got before the jury, such as the...
Through the cross and then the redirect?
And some of the direct, in the Commonwealth case, but that was through the individual doctors, like the one at Bridgewater who did the 2 competency hearings or 2 competency evaluations.
Or family members talking about being hospitalized or something like that? I don't know.
Yeah, but that was, that was a limitation, that he was hospitalized. He was hearing voices and was hospitalized, or
Yeah.
something, that's a generalization, but
Yeah.
to that effect. If I know that I'm looking at the clock, it's going faster than I hoped. If I can maybe just get into the Mutina issue, unless the court has more questions on. I know that Justice Spina, you took a real close look at this in Commonwealth versus Johnston, which was decided about a year ago. Once again, though, the defense attorney, Mr. Solomon, in this case, had real problems with the Mutina instruction. And, it really is somewhat of an ugly instruction, the way it tells a jury, don't worry about this. If he's acquitted by reason of lack of criminal responsibility, we got him for 45 days. And then if I want, after that 45 days is up, I can send him for an evaluation, or commitment, rather, for 6 months. So you're really saying someone's got 225 days of commitment for a not guilty by reason of lack of criminal responsibility. It's extremely troubling that that instruction is given or given the way it's
That's
Wasn't
not
it-
really what it says. I mean, he went on to say, if the person is still suffering from mental disease or defect and is still dangerous, he is kept in the mental facility. So as long as he's dangerous, he stays in the mental facility.
When you start listing the amount of days at the inception, and then you throw that in at the end of the instruction, I don't think it's compelling. I think it's actually somewhat troubling. I know
So what would you want to add to it? If the
Well,
person
I
is
think
still
something-
suffering from mental, he is kept in the mental facility potentially for the rest of his life? Is that what you're, is that what you're...
Absolutely. That's what the defense attorney in this case was looking for, because that's absolutely the truth.
Did he?
I'm sorry.
You go ahead. Sorry.
Or just be careful about instructing on it in the first place, as the United States Supreme Court said in Shannon. What's troubling about these instructions is that it is somewhat of a comment on sentencing. And that's one thing that this court always says, all our courts say, the jury is not to concern itself with the sentence. Or
It was done to help the defendant.
I understand that's
The
what...
jury otherwise may think that if it finds him not guilty by reason of insanity, he could walk out of court that day.
Did Mr. Solomon seek it? Did he seek an instruction on this?
He asked that, he did ask for Mutina. He said, I'm trouble with Mutina, but I don't know what to do, except I want this added language in there about that he may never get out, or something to that effect. So it's a little...
he said, do Mutina plus.
Right. And it's a little bit different from Johnston, because Johnston, they talked about a locked facility, and this court came back and said, well, that's not really an accurate statement of the law, because it might not be a locked facility. And so I understand that. Mr. Solomon came back here and said, I think we've got to do a little bit better than that, so this jury does have a better understanding that this guy just isn't going to walk away from this thing necessarily. He could spend the rest of his life. And I think the instruction just has to be significantly stronger for the jury to appreciate it.
Would the judge have been required to say, if he said he may be committed for natural life, or he may not be, because that's also true?
Well, I think in maybe gentler terms, sure. I think that would be much better than what we have right now. And that is a true statement of the law. I'm not sure that the statement of the law as given in the Mutina instruction is necessarily, although it might be considered a true statement, it's in my opinion, somewhat misleading. And Justice Gantz, I agree with everything that you said about Mutina being given for the benefit of the defendant. That's sort of the preamble, so to speak, of the Mutina instruction, but it doesn't do justice to what really happens in these cases. I did throw some statistical data in there. It's more just so the court can understand that there is a general perception that's not necessarily reflected in the instruction. I assume that these statistics are accurate and they're good statistics. I'm not sure there's a lot of quantitative material on this right now, but this was a terrible, terrible case. The jury obviously did not find that the defense was adequate in this case. I certainly all of the objective evidence supported the defense and seemed to indicate that Mr. Chappell was a deeply, deeply troubled, mentally ill individual at the time who could not control his behavior, conform his behavior to the requirements of society, and certainly fell within the McCool standard. But it just seems to me that the time is ripe right now to figure out a way to fix this instruction so that a jury has a better understanding of what's going to happen with these cases.
Okay, thank you.
Good morning, Your Honors. May it please the Court, Matt Sears on behalf of the Commonwealth. I'd like to start by addressing the issues in the same order that my brother addressed them in the
Before you
beginning.
get going on that, was there a cross of the expert by the prosecution?
There was a cross-examination by the expert.
There was.
By a cross-examination of the expert by the prosecution, there
Yeah,
certainly
there
was.
was a cross.
Yes,
So there was an opportunity for redirect.
there was. And Justice Gantz, I want to start with that point because there was nothing in the record, and I carefully combed through it, that was actually kept out. So I think one of the problems about that
But
we've had
you mean
discussing-
no medical records were kept out? Is
Well,
that?
there was no offer of proof by the defendant about what he actually wanted to admit here to support his defense. There was, during his direct examination of both Drs. Carroll and Dr. Warner, there was no objection by the Commonwealth that was sustained as to any underpinning about the expert's opinion.
You mean to any of the questions that he?
The only offer of proof, so, and as you can see in the record, there's a long sort of philosophical discussion about 703 and 705 and how they interact and about Grenadier and everything like that. At one point, Judge Locke says, what exactly is it that you want in? And the trial counsel says, all I want to say is, did you read this record? Was there a diagnosis in that record? And did that previous diagnosis form or direct your opinion? That's October 21st at page 178 and echoed at October 22nd at 467. That exact question was put both to Dr. Carroll and to Dr. Warner, both experts. Dr. Carroll at October 22nd, page 480, where he said, in my opinion, he met the criteria for diagnosis of schizophrenia. The question was, all right, and was your diagnosis based to any degree on the records which you read and the opinions contained therein? And he said yes. Dr. Carroll's, and this goes to a question Justice Botsford asked earlier, both Dr. Levitt and Dr. Carroll's medical records were entered into evidence. In Dr. Carroll's, well, the medical records contained in Dr. Carroll's report went back to 2007. There was a schizophrenia diagnosis.
So when
all the
you
way
say
back
his records, you mean the records that he was relying on?
some of the records that he was relying on, right?
So as a matter of practice, notwithstanding the language in our cases, beginning with DYS and going up and beyond Grenadier, do the lawyers and the trial judges allow some leeway in terms of what they allow expert witnesses to describe with respect to the bases of their opinions, even if those bases are not in evidence?
As a matter of practice, perhaps. I mean, I do agree with my brother that Judge Locke mentioned in the civil context where the litigation is heavily expert-dominated. There's a lot of that. I don't know in the criminal practice that that's correct at all. I think in the criminal practice, this court has taken the modest step of allowing a expert witness to testify based on what's gone before and based on data that's not admitted into evidence. But there is still a real concern about backdoor hearsay. That's why even when we have medical records hearsay exceptions, that statute is still subject to redaction, or those records are still subject to redaction and sanitation. It's all about the reliability of this, and that's what happened in Nardi. In Nardi, the Commonwealth called an expert and wanted him to be able to rely on some of the opinions of the former medical expert. And this court had problems with that, saying
It was the medical examiner, right?
medical examiner and some of his conclusions, some of his rather subjective conclusions, and this court said those still need to be subject to a reliability test. And that's basically what would have happened had the defendant chosen to admit these medical records. They still would be subject to reliability, would still be subject to hearsay.
But I mean, the obvious difference, which is, in the prosecution's favor here, is that, as far as I can tell, these records, these are prior admissions, prior treatment. They all would have come in under 79G, right? As opposed to Nardi, where we're talking about the person's dead, and this is the autopsy report, which is a different kettle of fish.
Perhaps. Again, I think in this case, there's much more space for that kind of backdoor hearsay that we're most concerned about. That these opinions are the reliability of these opinions were not adequately tested before they're placed in front of the jury. In any event, the defendant in this case decided he didn't want to do that. He was given the opportunity. And this goes back to exactly what the offer of proof was at trial. What part of the defense the defendant was not allowed to put in front of the jury. There was nothing that he was kept from putting in front of the jury. Not only was he able to, again, ask Dr. Carroll and Dr. Werner his proposed question that Judge Locke asked him during closing argument, he twice said, "You heard my doctors. You heard that they formed their opinions based on the consistent opinions that they had reviewed," and he'd used that to bolster both his experts' credibility and to try to impugn Dr. Kelly's credibility. You can find those at October 23rd, pages 93 and 104. So not only was he not prevented from admitting evidence that would support his defense, but he actually used it affirmatively. I guess I want to touch briefly on whether the rule should be different for the Commonwealth versus the defendant. And I think Johnston dealt with this issue. Johnston dealt with a lot of these issues. Johnston is an excellent case. It was decided just last year in April of 2014. Johnston, I think, very succinctly stated the defendant's right to produce all proofs that may be favorable to him, as provided in Article 12 of the Massachusetts Declaration of Rights, does not require the admission of hearsay. I mean, essentially, it kind of puts a garnish on the fact that this is a common law rule. This is a common law rule instantiated by the proposed rules of evidence 703 and 705. It gives the defendant more protections than confrontation. It's separate and apart from confrontation.
But I'm going back to something you said. If these are true medical records, admissible by statute, why do we get into what's hearsay in there? That they're in.
Well, I still think they're subject to redaction and sanitation.
Well, they may be for irrelevance, but I don't see why some doctor's opinion that's in a medical record from XYZ institution from 1989 is going to be out because you don't think it's reliable.
Well, I think it's still subject to a reliability analysis.
Really?
Why would that be if they're admissible by statute? You don't get past that.
Well, I think Commonwealth versus Hartman, 404 Mass at 316 through 17 still says that this is a hearsay issue within the statute. Hearsay is not admissible. It still has to pass all the protocols, all the procedures of hearsay.
So maybe you're speaking at the possibility that the medical history may include statements from other persons which may not arguably be relied upon by the doctors in their examination.
Yeah, yes. But again, in this case, the defendant had the opportunity. I just don't think this is the case to make this determination. It doesn't need to be because
it seems, in terms of our case law, once the prosecution opens the door by cross-examining and challenging the opinion, then all this stuff can come in, can it?
It can, and a lot of it did. During cross-examination, or excuse me, redirect, defense counsel did ask, did you review all these points? I think Dr. Warner testified that there are 300 points where there were some sort of hallucinations or something like that. It's sort of a jumping off point. I mean, once that door is opened, Attorney Solomon could have potentially admitted all of those medical records. I mean, the reason why he didn't want to is because he was concerned that the jury would fixate on something bad for his clients, cherry picking in the most classic sense. And that's what he said when Judge Locke invited him to admit the medical records. He just didn't want to do it, and that's trial strategy. I don't know that we need to change the law based on the defendant's trial strategy in this case. Moving on to the Mutina instruction, again, Johnston dealt directly with this issue in 2014. The defendant hasn't pointed to any issues that have changed since Johnson. I believe his social sciences report that he cites is from 1994. All that the Mutina instruction has to do is fairly inform the jury of the possible consequences of a not guilty for lack of criminal responsibility, and that's exactly what the model instruction promulgated by this court did. The model instruction, I believe, originated in March of 2013. That's the one Judge Locke decided to rely on.
Right, but our model instructions were limited to what the case law provides, and I understand your position that it certainly was not error to have relied upon it, but going forward,
Certainly.
would it make sense for those model instructions to add if the person is still suffering, I mean, what's there now, if the person is still suffering from mental disease or defect and is still dangerous, he is kept in the mental facility, would it not be clearer to say, comma, potentially for the rest of his or her life?
I don't, and for two reasons that were both discussed in Johnston. The first is that the instruction already does communicate to the jury that the defendant could be incarcerated for the rest of his life. I mean, it's clear enough.
I mean, clear enough because if you would put it, I mean, right now it says he is kept in the mental facility if he's still dangerous. So you're saying that implicit in that is that?
I think it's very straightforward, yes. If the person is still suffering from a mental disease or defect and is still dangerous, then he is kept in the mental facility. If the person is no longer mentally ill and can resume a normal life, he is discharged. The exact same add-on sentence, I believe.
Doesn't that last clause do exactly for the Commonwealth what the defendant wants to do for the defense? Only while he needs to be there, ergo, he's not there if he doesn't need to be. On the other flip side of that, he's still in for the rest of his life. It seems, why explain it if it's so implicit?
I agree.
In a way that benefits
I think it's gilding.
potentially.
Right. I think it's gilding the lily, and I think any further sentence actually could misinform the jury. And it's not just in Johnston that they found the proposed jury instruction didn't reflect the law because there was language of a lockup. It was because the proposed jury instruction could have communicated to the jury that there was a one-time commitment for the rest of the defendant's life. And I think if you look at the proposed jury instruction in this case, it's in the record appendix at page 19 and 20, you'll see that the instruction could communicate to a jury that there could be a one-time commitment for the rest of his life. And that's just not the law. And that's what Mutina is here to do, is to give the jury an idea of what the law is. The on appeal defense makes an argument about that Mutina should not have been given. First of all, the defendant asked for Mutina. Second of all, after Judge Locke said he's not going to give the defendant specific instruction, he said, defense counsel, do you still want this instruction? Do you still want it in the model form? And defense counsel said yes. So I don't think he can be heard to complain about it now or about shifting any burdens. And unless the court has any further questions, I'm content to rest on my brief for the other issues.
Thank you.